Ladies and gentlemen, welcome back to the Indie Zone podcast in a very long order rendered by Judge Stephen J. Hippler on the 18th of April 2025, memorializing to writing certain verbal proclamations from the bench that occurred at the April 9th, 2025 oral arguments on multiple motions in limine. The court rendered an order on state's motion in limine regarding AT&T Timing Advance Records. Here, the court says the state moves in limine to prohibit the defense from making any reference to the absence of AT&T Timing Advance Records related to defendant's cell phone. The state contends it never received such records from AT&T in response to its subpoenas, and therefore any statements by defendant that these records could have or should have been provided to defendant should not be allowed, as it mischaracterizes the evidence, will mislead the jury, waste time, and cause undue delay. In support, the state provides certificates of authenticity, AT&T for each of the two warrants, stating that it did not provide timing advance records for phone number, and then Mr. Kohberger's cell phone number is provided here. Because such records were, at the time, only available if requested within 7 days of the specified time frame. There is a footnote here, footnote 9, that explains the crimes occurred on November 13th, 2022. Defendant first became a person of interest on December 19th, 2022. The two AT&T warrants were issued on December 23rd, 2022. Thus, the timing advance records for a defendant that could have been of any relevance had long been discarded by AT&T and no longer exist. This order goes on to say, defendant, relying largely on the affidavit of its expert, Cy Ray, is adamant that the state did receive these documents, which he argues are exculpatory, and is hiding them. Defendant points out he has a constitutional right to challenge evidence against him and therefore must be allowed to explore the state's misrepresentation as to the availability of the records. And in the next paragraph, the court cites heavily to U.S. Supreme Court and also Idaho Supreme Court law in supporting the court's ruling here, beginning with the 6th and the 14th Amendments guarantee that a criminal defendant be provided with a meaningful opportunity to present a complete defense, which includes the right to confront and effectively cross-examine witnesses, and continuing on to cite heavily to U.S. Supreme Court and State of Idaho case law here in pointing out that these rights are not absolute and that a trial court may reasonably limit cross-examination that is harassing, confusing, repetitive, or only marginally relevant. The Confrontation Clause guarantees an opportunity for effective cross-examination, not cross-examination that is effective in whatever way and to whatever extent the defense may wish. Additionally, a defendant has no right to present irrelevant evidence, and even if evidence is relevant, it may be excluded in certain cases. The court then, having cited to this case law and this legal authority, then says, applying these principles here, defendant will be allowed to voir dire, special agent balance, outside the presence of the jury to ask whether he received defendant's timing advance records covering the early morning hours of November 13th, 2022, and the months prior when defendant was believed to have been in the area of 1122 King. However, if agent balance denies having received the timing advance records, defendant may not explore the matter further, either in voir dire or before the jury, given the absolute lack of any factual basis supporting his position that the state is hiding them. And then there's another footnote 10 here that says, Mr. Ray's affidavit, which forms the basis of the defendant's challenge, is replete with speculation and unfounded and thus highly improper accusations against the state. Further, not once in his affidavit does he address AT&T's 7-day retention period, which fully explains why the state was unable to obtain relevant timing advance records for the defendant. It concludes by stating, thus the state's motion is granted except as qualified regarding the very brief voir dire outside the presence of the jury. This will now conclude this episode of the Indie Zone podcast. Thanks for joining us here today.